Hi everyone, my name is Siti Maisara binti Ahmad Tamis, metric number 252682, and today the case that I'm going to review is Stirland against DPP. So for the facts of the case, on October 23, 1943, the appellant was tried at Central Criminal Court on a 12th count of accusation charging him with forgery whilst working with the British Broadcasting Corporation. Through cross-examination of prosecution witness, he put his good character in issue and he then gave evidence. In cross-examination, he was asked if he quit his past employment with Westminster Bank after being questioned about signature and a forgery. The accusation was, however, denied. So the issue of this case is whether the cross-examination was permitted. For the judgment, the Lords concluded that the cross-examination was irrelevant and not fair. However, nevertheless, there was no miscarriage of justice and the appeal was dismissed. In delivering the judgment, it is said that an accused who put his character in issue must be regarded as putting a whole of his past record in issue, and he cannot assert his good character in certain respect without exposing himself to inquiry as to the rest of his record, so far as this tends to disprove a claim for good character. So first and foremost, let's look into section 55 of the Evidence Act, where the word character is being explained, where it includes both reputation and also disposition. In the case of Bhagwan Swarup against State of Maharashtra, it is explained that there is a difference between reputation and also disposition, whereby a man may be reputed to be a good man, but in reality he may be a bad person. So this means that reputation is what other people think of a particular person, generally an opinion of the public of a person's character. Meanwhile, disposition is what people who are close to that particular person say about him or his character, meaning that disposition reveals who that person truly is. In criminal proceeding, the general rule is that good character of an accused is relevant and admissible, while the bad character of the accused is inadmissible. Character evidence in criminal proceeding is governed by Section 53 of the Evidence Act, 1950, for the good character evidence, and Section 54 of the Evidence Act for bad character evidence. Section 53 must be read together with Section 54, which act as the exception to the general rules. If the accused adduces evidence of his good character, he will lose his shield and face the risk of prosecution, who may adduce bad character evidence against him. Unless evidence has been given that he has good character, then bad character evidence becomes relevant. Other than that, Section 54 subsection 2 deals with the cross-examination of the accused, where a person who is charged and called as witness shall not ask or answer questions tending to show that he has committed or been convicted of any offense of bad character. So based on Stirland case, I learned that when we assume that we have done something within the scope of definition of Section 54 subsection 2, either good character or whatever. So if I have lost my shield, does that mean that the prosecution not entitled to ask me anything about my bad character? And does the judge still has this discretion to what question can be permitted? So here, I learned that we must cross-refer to Section 120 subsection 3, where it is very clear when it comes to cross-examination. The court has discretion to allow cross-examination, and the court can also stop the cross-examination. Just because you have lost your shield, the judge still have the discretion to determine what will be permitted and what will not, and it is not automatic. So cross-examination is permitted where necessary for creditworthiness, and otherwise, if it is not for this reason and overwhelming evidence of the accused, then cross-examination is not necessary. So in conclusion, I agree that bad character is inadmissible on its own without having to depend on whether good character is being raised as an issue or not. Because if a bad character alone is being looked into, then in my opinion, it will become prejudice to the accused, as the judge, when delivering judgment, he will be biased and have this thought at the back of his mind that the accused is a bad person. So this is because court must decide the case based on the facts and issues of the case itself, not really on the accused character. Other than that, for recommendation, in my opinion, it is best for the legislation to provide a more comprehensive guidelines on the meaning of reputation and disposition without having to cross-refer to any decided cases to know the exact meaning and difference between those two. Other than that, the law is uncertain on whether cross-examination is allowed or not. Hence, there is a need to have a provision that finalize the court discretion.